This is Liz Thompson at Stites and Harbison. I am coming to you today from beautiful Lexington, Kentucky, the horse capital of the world. And today I am here to talk to you about commencement of a bankruptcy case. A number of experts and I have recently drafted a publication called Surety Aspects of Bankruptcy Law. That's Surety Aspects of Bankruptcy Law. It is available on the ABA website, and if you are very interested in sureties and bankruptcy law, I encourage you to download that entire publication. This presentation today will be a very basic overview of a very small portion of that publication. There are many ways a bankruptcy case can begin. It can be voluntary or involuntary. It can be a Chapter 7, it can be a Chapter 11, a Chapter 5, a Chapter 12, a Chapter 13, and that can all be pretty confusing. Now, what do we mean when we say Chapter 7, Chapter 11, Chapter 5, 13, or 12? These are all different chapters or different ways that a debtor can file bankruptcy. The bankruptcy code, I've actually got a copy of it here in this book, and it's Title 11 of the United States Code, and each one of these bankruptcies or different sorts of bankruptcies that debtors can file under are separate chapters in these books, so that's why we call it a Chapter 7 bankruptcy, is because Chapter 7 of Title 11 provides for that type of bankruptcy. I said that the bankruptcy can be involuntary or voluntary. What does that mean? What it means is that a debtor can file its own bankruptcy. A company or an individual can decide to file, and they file their own petition. And that's a voluntary bankruptcy. Or creditors of the company or the individual can file a involuntary bankruptcy. And creditors can only file an involuntary bankruptcy under Chapter 7 of the Bankruptcy Code or Chapter 11. They can only file what we call a straight bankruptcy or a reorganization by filing an involuntary petition. An involuntary petition can only be filed in certain ways. If a debtor has more than 12 creditors, then there have to be at least 3 creditors who join in filing of the petition, and those 3 must hold over $16,760 of the debtor's claims. If the debtor has less than 12 total creditors, then a bankruptcy can be filed. An involuntary petition can be filed by one of its creditors, holding that same amount of debt. Now, why do involuntary bankruptcies get filed by creditors? Well, in the past, I've seen involuntary bankruptcies filed where there was fraud involved, where a large company was being run by a president who had decided to use it to operate a Ponzi scheme. And so to stop that fraud, the creditors got together and filed an involuntary petition. When circumstances arise where creditors feel like a debtor should no longer be in charge of its own operations and they need to take over, the involuntary petition is their method of doing that. Now let's talk about the different chapters that a petition can be filed under. Chapter 7 liquidation is the most common bankruptcy of all. It's what we call a straight bankruptcy. When a Chapter 7 is filed, and a Chapter 7 may be filed by either individuals or businesses. When a Chapter 7 is filed, there's a trustee who's appointed, a Chapter 7 trustee. And the Chapter 7 trustee takes control of all of the assets, liquidates the assets, and pays the net proceeds, if any, to the creditors of the case. So it's the Chapter 7 trustee's role to collect and distribute any assets in a Chapter 7 liquidation. And that's the most common sort of bankruptcy filed. Usually, creditors receive no distribution at all in a Chapter 7 liquidation. Unsecured creditors receive no distribution at all. Secured creditors may get payment on their debts. If the debtor wishes to keep their home or car, they could reaffirm. But generally, there is no distribution to unsecured creditors in a Chapter 7. Chapter 11 Reorganization. This is the kind of bankruptcy that most sureties are going to deal with because most businesses that are large businesses and file bankruptcy are going to file a Chapter 11 reorganization. It's usually for business entities, but individuals who have a whole lot of debt and maybe complex ownership can also file Chapter 11 if they see some benefit in doing that, or if their debt is so large that they have to file a Chapter 11 reorganization. In the Chapter 11 reorganization, the debtor continues to operate its business. There's no trustee who's appointed generally. For a cause, one can be appointed, but generally in a Chapter 11, there's no trustee appointed, and the debtor is going to continue to operate its business. We call the debtor in bankruptcy a debtor in possession for that reason, because the debtor is in possession of its assets and continues to operate its businesses. A Chapter 11 can include a partial liquidation of assets or a plan of reorganization where the assets are reorganized, or both. They can do both liquidation of assets and reorganization of operations. In a Chapter 11, boiling it down to the very basics, after a petition is filed, the Chapter 11 debtor is required to come up with a plan of reorganization. And so they are required to file a disclosure statement, which has a bunch of information in it, in the nature of a prospectus that would be required for the sale of stock to inform the creditors regarding the company. They have to file a disclosure statement, the debtor does, and a reorganization plan. And the plan will propose how the business of the debtor is to be reorganized and what is to happen with its assets. Creditors may then vote to accept or reject the plan, or they can file objections to confirmation of the plan. But even if objections are filed, or there are votes against the plan, the court may still approve the reorganization plan over objections. And even if not all of the creditors vote for the plan, or the creditor classes vote for the plan, so long as the plan is otherwise in compliance with Section 1129 of the Bankruptcy Code. There's a new subchapter 5 to Chapter 11. It's a Small Business Reorganization Act of 2019. It was just enacted in 2019. And what happened is that Chapter 11s are very expensive. Companies spend hundreds of thousands of dollars sometimes on attorney fees for the attorney for the Chapter 11 debtor and the attorney for the creditors committee. All of these fees are very expensive and really more than a lot of small businesses could afford. Also, a Chapter 11 reorganization usually takes several months. It usually takes several months to come up with a plan and a disclosure statement and for the creditors to vote on that plan. And a lot of small businesses just don't have that much time or that much money. And so In 2019, the Small Business Reorganization Act was enacted. The purpose is to streamline the process for small business organizations, to limit expense, to make plans get confirmed more quickly. In a subchapter 5, a trustee is appointed to oversee the business, and the trustee is to mediate a consensual plan. The plan is a much more simple plan. It looks sort of like a Chapter 12 farm plan or a Chapter 13 wage earner plan. It's a much simpler plan in most cases. Under subchapter 5, a debtor can repay their debt in 3 to 5 years, but the debtor has to put all of their net disposable income into payment of the plan over that period of time. Another type of bankruptcy I've talked about is a Chapter 12. Chapter 12 are for family farmers and fishermen. Sureties don't get involved a lot in Chapter 12, but I assume they could. In order to file Chapter 12, debtors must have at least 50% of their gross income from farming. They must have debt of less than $4,153,000, and 50% of that debt must come from farming. In a Chapter 12 farmer reorganization, the debtor proposes a Chapter 12 plan. It's a much more simple plan than a Chapter 11 reorganization plan, and generally they look a lot like a Chapter 13 plan. In a Chapter 12, a Chapter 12 trustee is appointed to oversee the process and will generally make distribution to the creditors. The next chapter that I mentioned is a Chapter 13. A Chapter 13 bankruptcy is for individuals with regular income, or we call them under the bankruptcy code wage earners, and they propose a wage earner plan. In order to file a Chapter 13, an individual has to have unsecured debts less than $394,725. They have to have secured debt less than $1,184,200. And businesses can't file Chapter 13s. Only individuals can file Chapter 13s. The debtor has to pay all of their disposable income into the trustee. Generally, plans go from 3 to 5 years, so they have to pay all their disposable income in for the period of the plan to satisfy their debts. A Chapter 13 trustee is appointed in a Chapter 13, and the Chapter 13 trustee oversees the bankruptcy. They recommend confirmation of the plan or not, and they usually receive the payments from the debtor and make distribution to the creditors. There are also municipality bankruptcies. Sureties could very likely become involved in municipality bankruptcies. Municipalities are entities that qualify for Chapter 9 are state entities. For instance, the state of Kentucky or the Commonwealth of Kentucky, any entity that is formed as part of the state of Kentucky would be able to file a Chapter 9, which would include all of our cities and municipalities. The last kind of bankruptcy we're going to talk about is a Chapter 15 bankruptcy. Chapter 15s are very rare, but sureties can get involved in those types of bankruptcies. Chapter 15 bankruptcies happen where a foreign company files bankruptcy in a foreign country, but has an asset in the United States that has to be administered, real estate or other assets. In that case, a Chapter 15 is filed in the United States so that the foreign bankruptcy case can coordinate with the Chapter 15 case to deal with those assets of the foreign company located in the United States. And that's all I have to tell you about commencement of cases today. As I said, this was a very basic overview, and if you are interested in the topic of surety aspects of bankruptcy law, I encourage you again to look on the ABA website for our publication, Surety Aspects of Bankruptcy Law, and it goes into a lot more detail and a much more in-depth analysis of all the aspects of bankruptcy law that may impact sureties. Thank you and take care. Bye now.